Welcome to The Dad Lawyer, a program produced by the Parents Estate Planning Law Firm in conjunction with ActonTV. I'm your host, David Feakes, founder of the Parents Estate Planning Law Firm in Acton. The Dad Lawyer is a program for parents with young children and highlights the legal and financial issues that are specific to parents and growing families in Acton and the surrounding communities. So on today's show, one of the things that's been happening at the Parents Estate Planning Law Firm is, number one, we've been growing, and I'm joined today by our new associate, Amanda Mulhall. We're going to be talking guardianship on today's show. But before we get started on the show, I just wanted to introduce Amanda and welcome Amanda and let Amanda share a little bit of background about herself. So Amanda, welcome to the show.
Hi, thanks, David.
And tell us a little bit about yourself and your practice before you've joined us.
Sure. So I've been doing estate planning since I was a second-year law student in Boston. I lived in Boston for about 10 years, worked at a couple different law firms before landing at the Parents Estate Planning Law Firm.
And what is it about working with young families that particularly appeals to you?
So in my training doing estate planning through law school and after law school, there's a lot of emphasis on older people doing planning for Medicaid planning and doing estate tax reduction, which is all really important. But I think that what I've learned just being here for a few months is how important it is to do this planning for younger families. Because although they don't have the same types of issues as older people, they have a whole different set of issues which often aren't addressed by typical estate planning attorneys. And one of those issues that's really central to what we do is guardianship.
And since you've been with us for about 3 months, anything interesting that you've discovered since you've joined us about working with families with young kids?
It's really interesting to see people through the learning process. So a lot of times people don't really think about estate planning until it sort of is right in front of them. So I've learned a lot about informing people about why it's important and having them be ambassadors in their communities so that they can teach their friends and family members about the importance of estate planning in their lives.
Awesome. Well, we're delighted to have you as part of the team, delighted to have you today on the show. We're going to take a quick break. When we come back from the break, Amanda and I are going to be talking about everything that you need to know about naming guardians for your kids, including the 6 most common mistakes that parents make when they name guardians for their kids. And we'll also talk about things that you want to be thinking about and preparing for as you name guardians for your kids. So we'll be back right after this.
You can be a hero by being prepared for an emergency. First, make a plan. Call a family meeting to plan for things like how to connect with loved ones after an emergency or your escape route.
I am not fast.
Build a kit. When disaster strikes, it's important to have enough supplies to last 3 days. And don't forget the batteries.
Low battery.
Visit ready.gov/kids for more preparedness tips.
All right, we're back. Welcome back. Again, I'm David Feakes, the host of The Dad Lawyer, and today I'm joined by Amanda Mulhall from our office at the Parents Estate Planning Law Firm, and we're talking guardianship. Guardianship, what I always say about guardianship is that it is the most important decision we make as parents of young kids, choosing who we're going to name to essentially raise our kids if for any reason we're not there to raise them ourselves. There's a lot of statistics that get thrown around about the percentage of parents who have not yet named guardians for their kids. The one that I hear most consistently is about 69%. Some people may say 74%, some people may say less. But I think what Amanda and I could probably both agree on is that the majority of parents in the United States have not yet named guardians for their kids who are under the age of 18. And planning is the only way to make that happen. So I want to dive into the mistakes. There's 6 of them that we're going to talk about today. And the very first mistake is only naming one possible guardian. So what will often happen is you'll go to an estate planning attorney and they'll ask you to name a guardian for your kids. And you'll give them a name, maybe it's a couple, but you'll stop there and you won't ever get past that one guardian. And that can be a mistake in and of itself, because if something happens to your guardian, you got to make sure that there's a backup in place. Amanda, what else about naming guardians stands out to you as a potential problem in the planning?
Sure. So naming a guardian is a really difficult thing that I find that clients can sometimes struggle with, because it's a really big decision that oftentimes they haven't really thought of in depth before. So a lot of people get hung up on that. And what I like to tell them is that it's not so important that your guardian is the most financially stable person that you know in your life, potentially. It's more important that you're choosing someone who will provide a loving environment for your kids, who are going to raise your kids essentially the same way that you would raise them, and they share your values. And that's the kind of people that I like to advise their clients to choose as guardians.
So the one thing that I find very often is some people are stuck on only one named guardian because they can't really get past the one. Sometimes we find that, and we should maybe start here as well, is that clients can't even get to one,
Right.
because they run into what I would call the barrier, which is my parents are too old, my siblings are too young, or they're not at a place in their lives where they would be mature enough to take care of my own kids. And what families can bump up against is what I would call that wall, where they don't see a way through it or over it or around it or underneath it, and then they retreat and they don't do anything at all. But generally, I would always say to parents, you want to make a list of everybody you can think of who could potentially be a guardian, and then you want to compare that against a list of what it is in terms of attributes that you would most want from your most desired guardian, and then to work off of that. But to start with making a list of everybody who could potentially be a guardian. Anybody who's better than the Department of Children and Families, we would say, better than that. It could be family members, it could be friends. People tend to stop at family members and not go any farther than that, because there's this thought that it's got to be a family member who's taking care of my kids. But sometimes the very best person to take care of your kids could be a really close family friend. So you'll also want to be looking at things like values and belief systems, and where you would want your kids to be raised. When your kids are really little, 2, 3, 4 years old, proximity is not often that big of a deal, because it's easy to pick up and move kids who are still kind of in preschool age. But as the parents of teenagers myself, I know that once they get to be middle school and high school age, then that becomes a really significant concern. So that would be mistake number one.
Absolutely. And that sort of leads us to mistake number 2. Once you've gotten that first guardian down, a lot of times people name couples, which is a great thing to do. They want their kids to be raised by, whether friends or family who is a married couple that will raise them similarly to the way that they would raise their own kids. But that presents its own set of issues that a lot of times people haven't even thought of before. And that includes, what would happen if one of the people in that partnership was to either pass away or become incapacitated, the couple was to divorce. What would you like to happen in that scenario? And that sort of raises sort of like some red flags for clients, because they're not thinking that way. So we like to get them to think that way, and that sort of opens the door to naming successor guardians, people who can step in to take care of your kids if something happened to that first couple that you named.
And we always say that when you're naming a couple as a guardian, the follow-up questions that we always ask is, can either of them serve alone? Can both of them serve alone? Or can neither of them serve alone? So those are basically the 3 scenarios. Some clients will name, if you say, for example, I want to name my sister my brother-in-law, then we have to ask the follow-up question. Can your sister serve alone if something happened to your brother-in-law? Can your brother-in-law serve alone if something happened to your sister? And sometimes the answer is yes, either of them can serve alone. I trust them both. They could both raise my kids. Sometimes the answer is only my sister. I'd only trust my sister to raise my kids. Sometimes the answer is usually in reverse. If we say brother and sister-in-law, sometimes we get, well, only my sister-in-law can raise my kids, but I don't trust my brother to raise my kids. And sometimes the answer is neither of them can serve alone. And so then we want to make sure that we're going back in and making sure that the formal guardianship nominations on the documents themselves reflect what it is that's most important to the clients. So if neither of them can serve alone, that's where we get, it's critically important to get down to a backup guardian. Because if you're riding in a car with your sister or your brother-in-law and something happens and neither of them can serve alone, then by default we have to go to a backup plan. But if either of them can serve alone, then we got a little more flexibility in the plan, we've got a little more time in the plan, but still always want to get to a backup. And yeah, we always want to deal with things like divorce. What should happen in the event of divorce? And the beautiful thing about the drafting that we do and the software that allows us to draft the way we do is that allows us to get a lot of that flexibility when we're drafting the documents themselves.
Sure, and even one other consideration, sometimes, because we deal with a lot of young couples, they would like to appoint their own parents as the guardians of their kids, which is sort of the natural thing for people to want to do. But at which point are your parents maybe not of the age where they can raise really young kids? So even though it's good for now and it's the right fit for now, we always encourage our clients to come in to review these things every 3 years, especially because with the age range of people that we work with, that when they're appointing an older generation to come step in and take care of their own kids, it might not look the same in 10 years as it does today. So that's another important consideration.
Yeah, as we always say, parents age out of the role, and sometimes those younger siblings who weren't right for the role when you were first doing the planning age up into that role. And so when we get together on client review meetings, that's often a time when we're looking back on the guardianship nominations and seeing that it's time to make some changes because your 65-year-old parents are now 75, and maybe they're not in the best place to be raising what is now a preteen or a teenager, which gets more difficult with time. Sure. Mistake number 3 is only naming guardians in a will. So talk a little bit about where that can go wrong in the planning.
Sure. So as I mentioned earlier, I've been doing estate planning since I was a second-year law student, and until joining our firm, I learned the traditional way of naming long-term guardians, and that is by drafting a will and putting it in your will. So if something happens to you, you pass away, these are the people you want to step in to take care of your kids. Unfortunately, that is not the most comprehensive way to deal with this issue, and I didn't realize that because everyone does it this way. But what we do instead is we've noticed that there's a gap in there, because if something happens to you but you don't pass away, no one is filing your will anywhere. No one is giving your will to the probate court because you haven't passed away yet. So what happens to your kids in that scenario if you're just unable to care for them anymore? So the way to get around this is by creating what we call a nomination of guardianship form, which names the exact same long-term guardians that are in the will, but it takes it out of the will and it puts it into a document that you can offer up to a judge when they're making that long-term guardianship determination, that will express your preferences without leaving it up to your family to either decide for you or leave it up to the court to decide for you, or at least leaves your family saying, what do we do now? And that is what estate planning is. It's taking all of these contingencies and planning for all of them. So it takes those questions off the table for your loved ones.
Yeah, so I always say to clients, part of the planning is what happens if you die. Part of the planning is what happens if you don't die. And so guardianship is not just about what happens if we die. Guardianship is what happens if we can't take care of our kids, one way or another. What if we're incapacitated for an extended period of time? And so you're right, that naming guardians in the will is part of the plan, part of the solution, but it's not all of the solution. And that incapacity piece has to be in place around guardianship as well. And the other great thing, what I love about practicing in Massachusetts, is the ability to name to create the appointment of temporary guardian or the appointment of temporary agent, which allows clients to name guardians who can step right in if either they've died or they've become incapacitated and handle everything for the first 60 days. And that allows a really easy, smooth transition. It allows everybody to focus on the needs of children first and foremost, without worrying about having to go get orders from a court in order to take care of kids or make decisions for kids. So that's a great piece as well. Which brings us to mistake number 4, and where I think probably our firm does things a little bit differently, and that's mistake number 4 is not naming what we would call short-term guardians for your kids. So share a little bit about that mistake.
So what short-term guardians are, they're your first responders. These are the people who, if they get a phone call saying, Johnny and Susie are at home, something happened to their parents, we need someone to come take care of them until we can get whatever needs to be squared away. And these people are, 15, 20 minutes away from your house, people that you trust, who can stay with your kids for a few hours, a few days, until authorities, if something were to happen to you, say example, you got in a car accident and your kids were at home with the babysitter, and a police officer showed up and they needed somebody with legal authority to be on the scene immediately. But sometimes your long-term guardians aren't right by, nearby. They could be a few hours away. They could be a plane ride away. So these short-term guardians are the people who can step in while your long-term guardians are being identified, notified, and they can actually show up on the scene to take custody of your kids.
Yeah, so that's the piece, that even, it took me a long time to figure out this piece. And it was the kind of thing that Paul and I recognized in our own family that this was missing. I always tell clients at workshops, I always tell the story that Paul and I, when the kids were really young, maybe Sadie was a baby, Hannah was 4, 5, maybe 5 years old, they were home with a teenage babysitter a lot. There was a family we used in town where there were 3 sisters all in a row, and we kind of used them sequentially. Started with the oldest, worked our way down to the youngest. But Paul and I had what we called a standing date night every other Thursday night, where for a couple of hours we would go out. Sometimes it was just to the library to read a book, but basically just to kind of clear out. But on one of those date nights, when we were riding home, we were talking about what would happen if something happened to us on the car ride home, and would our babysitter know what to do? At that point, the kids weren't really old enough. We had guardians in place. At that point, the kids weren't really old enough to kind of vocalize, here's that my sister, my brother-in-law were our long-term guardians, or how to get in touch with them. And I realized, and we both realized, that if a police officer showed up on our doorstep, that the babysitter wouldn't know what to do. The kids obviously were too young to know what to do. And and I knew as the lawyer that there was this very real possibility that our 2 daughters could be removed from our home and placed in the hands of strangers. And just as we were talking through it, I felt it, I know Paula felt it too, just in the core of our gut, that clenching. And I knew right on that ride home that I had to figure out a way to solve that problem. And we solved it in our own plan. We built it into the planning of all our clients. And it's really one of the reasons, as you know, that we go out into the community and teach so much, is teaching around naming short-term guardians, because parents just don't know that. They don't think about it. Most traditional estate planning attorneys can't and won't help them to think about it because they're not thinking about it. So I would call that kind of a mistake of omission, because parents, they don't even know it's not even really a mistake, because they just don't know to plan for it. But once they do, boy, eyes go wide, and that's the thing that really gets them. But yeah, that would be mistake number 4. And the people are people who are close to where you live, friends, neighbors. I probably have it in my wallet right now. I could pull it out. And that's the emergency ID card that we create for our clients. It's one of the things that I carry around in my wallet still, and Paula does as well, because we have an under 18-year-old who's old enough to take care of herself, who's home a lot. And I want to make sure that if I'm ever in an accident, somebody knows that there are people who live really close to where we live who can come over and take care of her immediately. So that's a critical piece.
Yeah, and for some clients, this is an easier thing to plan for once they're aware of it than the long-term guardians, because they know who lives near them. They know who their friends are. Sometimes clients who have really young kids who are like a year old, who might be new to the community that they live in, they might struggle a little bit, but once kids, they're 10 years old, they know all their kids' friends, parents, and all that sort of thing. So this is usually a little bit of an easier one for parents of young kids, which is good because it allows them to sort of take the right steps to get all this in place.
Yeah, sometimes that list is 1 or 2 at the beginning, and as we always say, some plan is better than no plan, even if it's not the perfect plan. And then I always promise parents, because I have experience behind me, as to how this works, but that as time goes on and your kids enter the school system and they make friends and you become friendly with the parents of their friends, expanding that list is really easy. And I always joke that there's about 10 or 15 people who live about 5 minutes from my house that my younger daughter would be very happy, not happy to be with under the circumstances, but would be comfortable being with in an emergency. So that's an easy one to take care of. All right, so give us number 5.
So the 5th mistake is leaning more towards the financial end of things, the supporting your kids. And one mistake that people sometimes make is they appoint the financial decision makers for their kids as the same people that they appoint as the long-term guardians of your kids. And that's not always a good idea. If you have someone managing the financials on behalf of your children, you want those ideally to be separate from the long-term guardians. And the reason for that is there's a potential conflict that's sort of inherent in that relationship that I think you might be able to expand on a little bit.
Well, what we would say is that the people who raise your kids and the people who take care of the money for your kids, there is an inherent conflict. Not an actual, like, no matter what conflict, but there is a potential conflict there. And here's how it works, is that the people who are raising your kids are taking care of them, and they're incurring some level of expense in taking care of your kids. Now, the people who are taking care of the money, what we would call the trustees, they have what we would call a fiduciary or legal obligation to manage and invest and distribute those resources in the best interests of the children who are the beneficiaries. And only in their best interest. So obviously a trustee can't use the money for themselves. Now, when you have a guardian and a trustee in that dual role, then there's some overlap and you start to see the potential conflict. Well, little Johnny I want to give them piano lessons, or maybe I've got 2 kids of my own and now I've got 2 kids that I'm bringing into my home, and so I need to renovate the house. But am I renovating the house for my benefit, or am I renovating the house to provide a comfortable environment for the kids? Sometimes it gets very muddy in the middle there. So we would generally say that ideally that you would separate the role of guardian and trustee, while we recognize that that's not always possible. And I always use the example of my own family, because my brother-in-law is one of my guardians with my sister, and he's also in line to be a trustee of my trust. But as I always say to people, there's no one I trust more in the world with my kids and with the money that would be there to take care of them than my brother-in-law. So it's really all about understanding that there is a potential conflict there and then making informed and intelligent decisions around that.
Yeah, sometimes people, when I'm dealing with clients and I'm explaining this to them, they will think, well, I trust this person, implicitly. They're taking care of my kids. Of course, I trust them to do the right thing with the money. But really, you're doing them the favor by just taking that off the table. If you can put someone else in the role of trustee, then that's not even going to be an issue going forward, so there won't even be a question. So that's kind of how I put it to people who want to put their faith in the people that they're naming, which of course they should, and they are, by naming them in the first place. But it's almost like the client can do them a little bit of a favor by just taking that off the table.
And then final mistake is, and this is another one people don't tend to think about a lot, is not excluding people that you know you don't want to be the guardian. So in some families, there are people that you just know, I don't want this person to be the guardian. And they're a family member, and I have this fear that they might challenge the decision that I've made. And so it's important for parents to know that they can exclude people and keep people out of that role. And so talk a little bit about kind of in our office how we go about doing that.
Sure. So we have a document that we can draft for clients that is a totally confidential document that will never see the light of day until the person that they've excluded from their plan actually is in front of a judge petitioning the judge for guardianship of their kids. So unless that situation was to arise, which it very possibly could, this is not a document that our clients have to ever tell anyone else about. They don't have to let anyone know about it. It's just there sort of as a way for them to express their wishes to make sure that their children don't end up with somebody who might look good to a court, but might not look good to them. So there's a pretty classic example of, say I had two sisters, or a sister and a brother, and the sister had a family and lived in the suburbs and had kids of her own and a dog, and my brother lived in an apartment and he had a job, and he, maybe didn't look on paper to a judge or a court like he would be the ideal guardian for my children. But in fact, I know that my brother is the person that I would want raising my children in my place. Even though my sister, looks like she has it all and could provide a great family for my kids, I might say, I wasn't really wild about the way that they raise their kids in this certain circumstance. So it's just a way to express your preferences, to avoid, just sort of arbitrary court interference with that.
Yeah. And as we always say to clients, the exclusion of guardian stays in the binder, doesn't come out of the binder. We're not publishing this anywhere. We're not putting on a billboard, and they really appreciate that. So those are the 6 common mistakes. Number 1, only naming one guardian. Number 2, naming a couple as a guardian without provisions for what we would call life events. Number 3, only naming guardians in a will. Number 4, only naming long-term guardians and not having the short-term guardians in place. Number 5, naming the same person as both guardian and trustee and the potential conflict around that. And number 6, not excluding undesirable guardians if that is the case in your family. So those 6 common mistakes are something that we share with prospective clients. If you would like a copy of our 6 most common mistakes parents make when naming guardians, you can get that from our website on the resources page. Again, parentsestate-planning.com on the resources page. At the very least, you want to make sure that you have an estate planning attorney walking you through naming guardians for your kids and thinking about all of these things that we've talked about today so that you don't end up making those mistakes when naming guardians for your children. So I want to thank you for joining me on this edition of The Dad Lawyer, and I hope you'll join us again next month. If you have any questions at all about today's discussion or about legal planning for your family, you can visit our firm on the web at parentsestate-planning.com, or you can call our Acton office directly at 978-263-6900. For additional articles, information about legal and financial challenges facing parents of growing families, please visit thedadlawyer.com. Thanks again for joining me, and I'll see you again next time.